Howdy. This is our third and final video on the Introduction to Cybersecurity Terminology and Concepts. The second video ended rather abruptly, and I apologize. I attempted to use different software than I used in the spring for this online course, which I wasn't happy with it in the spring, and I'm still trying to figure out some of the little peculiar aspects of this software, so please bear with me. I want to pick up where I left off, which we were talking about, is the smartphone legally a computer? Is a poker machine legally a computer? What's our analysis going to be? Our analysis is going to be, is there a legal definition of a computer? And guess what? Yes, we found a legal definition of a computer under the CFAA, the Computer Fraud Abuse Act, and we'll talk more in depth about this law. If someone's going to be prosecuted, a lot of times they will go to this law. Because basically it says it's illegal to intentionally access a computer without authorization or an excess of authorization. Okay, sounds good. Of course, it doesn't explain what without authorization can actually mean. If I tell you to get on my computer and look for a file, and you look at other files, is that without authorization? Or if I tell you to do something, and while you're doing that, you see something else, you know, we're lawyers, we like to argue. But the CFAA does define computer in a rather, I think, humorous sense, since if I ask you to define a computer, I don't think you'd come up with this definition. But it's electronic, magnetic, optical, or electrochemical, it's high speed, it performs a logical, arithmetic, or storage function, da-da-da-da-da-da. So in the United States v. Neil Scott Kramer, Mr. Kramer used his cell phone to solicit an underage girl. And there weren't very many good laws then, and I don't know what all the facts were on this case, but it was egregious enough that the United States brought a federal action against him under the CFAA, and he was found guilty. So he appealed in whatever state he was in, and it went up to his appellate court for the 8th Circuit, and the 8th Circuit affirmed the conviction, found that a cell phone can be considered a computer if it performs arithmetic, logical, and storage function, and so yes. So let me think about this. I don't know when the last time you used your cell phone for arithmetic or considered the logical and storage functions beyond your camera, but it didn't matter. The computer, as defined in the CFAA definition, fit the cell phone. The conviction was affirmed, and it immediately paved the way for harsher consequences for criminals engaging with minors over cell phones. Now, I'm expecting you to be thinking of this, but wait, this is the Court of Appeals for the 8th Circuit, so it is only binding on those states in the 8th Circuit. That's true. It is binding on the states on the 8th Circuit. However, this is what we call a persuasive opinion. The other circuits can use this legal logic. It is persuasive. It persuades them to do it. That opinion from the 8th Circuit is not binding on the other 10 circuits. However, it became a landmark case and is referred to in this type of crime. The second example is United States v. Kane, 2011. And I always think they should make a movie about this. These two gentlemen discovered a software bug in a poker machine. So there was a vulnerability, and they exploited that. And they ended up with like $400,000, not a big bunch of money, not like, you know, Ocean 11 or something. And they were prosecuted under the CFAA. And in that case, the conviction was not upheld because the poker machine in question was not a protected computer, and it did not, meaning specific government, obviously it wasn't government or financial computers, and it didn't uphold to the computer definition, so therefore they could not be tried under the CFAA. So I hope from this you see my analysis of why we look at the legal definitions, even though technically we might find the definitions somewhat numerous. Okay, so we're going to go on. We're not going to end here, but an assessment activity that I want you to do, either on your own or when we do a discussion group or something, look at the terminology and go through those two online sources and find out which terms have legal definitions and which do not. And you might want to find legal definitions for 5 cybersecurity related terms. or not, or think that the word's going to have one. Actually, you need to be a little careful. If you look up computer in the two sources I gave you, it does not refer to the CFAA definition. I don't know why, but it does not. Okay, so let's go on. Let's finish this up. Why am I doing this? Because there's been a trend in cyber attacks and hackers in the last 20 years, and this is reflected in the law, going back to our first principle that the law always lags technology. So you need to be able to relate these trends to the current types of cyber attacks and the associated law. You have to understand what motivates them, because this will be questions of jurisdiction and also what type of law you are prosecuted under. And you need to understand different principles of security. And as you go through Chapter 1 with the FTC, look how these principles are discussed in the FTC actions. I should add one little principle here that we again will talk about later. We are going to eventually get to a topic called hacking back, which is when you go from being on the defensive to the offensive. And one of the things that we worry about legally is this. If you are hacked or attacked by a person or an entity, that comes under rules of law. If you are attacked by an entity that turns out to be a nation state, technically it can come under rules of international law, but it actually invokes rules of engagement, depending on the circumstances, which are acts of war. And this you're going to see when we talk about hacking back. And I want to relate this to what we're here on the third learning objectives, how the trends and the like are in the current types of cyber attacks. Who do we attribute the attack to? What is their motivation under the fourth learning objective? Is their motivation political? Is it nation state? So attack sophistication has increased over time, but the knowledge necessary has decreased. So what does that mean? I refer to it as the agnostic state of cybersecurity, or the capitalization, like in We Are All Capitalist, of cybersecurity. Old-time attacks were disrupted operations, made a point, gained some notoriety. But now the sophisticated attacks are more about criminal intent or nation-state intent, or something much more nefarious, while the attacker knowledge has actually decreased. What it takes to be an effective attacker, go back to our triangle of the elite, the script writers, and the script kiddies, has gone down. And we've talked about this before. So this is something else you want to do sometime, is keep up. This is throughout this class on latest type of attacks. What's the strategy? What's the level? Are they targeted? Are they opportunistic? Why is the analysis of this important in the legal sense? And that's what I've alluded to earlier. Is it going to be rules of law? Is it going to be rules of engagement? Go back to our definitions of jurisdiction and the like. Okay, so let's talk about hackers. What do they want? They want money. They want to disrupt operations. They want notoriety. They want to make statements. They want revenge. And sometimes they just want to have fun. Doesn't matter on the legal consequences, other than the bifurcation between rules of law and rules of war. So how do they attack? Weak or unsecure passwords, hand-patch systems, social engineering, all these things. Why is this important to us? In my next lecture, when I discuss Chapter 1, you will see that right on the first page of Kossoff's book, they talk about the word reasonable steps. Reasonableness is a standard of duty, of care in the legal sense. So if I can defend my hacker, or if I'm, let's say, a victim of a data breach, this is a better example. If I'm a victim of a data breach, and I can prove that the entity that was just to protect my data did not use reasonable care, did not take reasonable steps, did not use what's called the reasonable person standard, and what would that be? And it's these kind of things. Did you patch the systems? How did you protect me about this? How did you protect me against insider threat? And the like. So, what's the consequence of attacks? This is important because many times, legally, if you aren't being in violation of a criminal statute, but you're worried about civil litigation, you will make a business case and you will put in effect lax security because it's cheaper to pay the regulatory fines. We'll talk about this as well. So the consequence of attack, damage to the information system, fines and penalties, and those all-important legal fees, decreased productivity, critical business information, a big one, damage to reputation and loss of trust, the like. So this becomes important in law for a couple of reasons. One, what is reasonable? And we'll be talking more in depth about this. Did you use reasonable steps to secure systems? Did you use reasonable industry practices and the like? The second, where the consequence of attacks come in, is in the unintended consequences. Go back to this spring with Facebook and Cambridge Analytica. Cambridge Analytica scraped data. They didn't hack, they scraped data off Facebook profiles. Did they pay for that? No, they did not. So, but did they break a law? No, they did not. In the end, Facebook lost a lot of reputation and a loss of trust, which was a consequence, but yet did not run afoul of the law. So let's talk about the 4 principles of cybersecurity. First of all security is based on risk, so absolute security is unachievable. And we take this in account. When we talk about in tort, we talk about negligence versus gross negligence. We'll get to that. The objectives of security are our old friend CIA, plus authentication, authorization, auditability. As you read Chapter 1, the key lessons and the guidelines and recommendations from the FTC, be looking for these words. Security is only strong as the weakest link, and unfortunately, it relies on people. So, here's how the key points I want you to take away. We've used 3 videos to establish a common basis of technical terminology in cybersecurity. We understand the difference between and importance of technical and legal definitions. And now on this basis, we'll begin to analyze key legal definitions in a subsequent lecture. I want you to think about this, and if you don't know who Aaron Schwartz is, research and find one criminal prosecution or legal proceeding that seems unfair. That is, it was perfectly legal, but was the outcome just? And we'll put this on a discussion post. Thank you for your time, and we'll move on in our next video to Chapter 1.